If you're a solo or a small firm attorney, your clients are relying on you to protect their interests. This is one reason why succession planning should never be viewed as optional. However, every bit as important are the rules of professional conduct, because your ethical duties don't just vanish into thin air should you become disabled, incapacitated, or pass away. Thus, these ethical obligations are another compelling reason as to why succession planning must be on every solo and small firm attorney's must-do list, as opposed to being tossed into "I'll get to it someday" task pile. With that said, let's break this down by reviewing the 5 rules that make or break succession planning. 1. The duty of diligence. Rule 1.3 states that you shall act with reasonable diligence and promptness in representing all clients. If you're suddenly no longer able to practice and there's no one prepared to step in, your clients' matters and sometimes their rights can be put at risk. A succession plan helps ensure that this won't happen. 2. The duty of communication. Under Rule 1.4, you are to keep clients informed about the status of their matter, promptly comply with requests of information, and enable them to make informed decisions about their representation. If you are no longer available, compliance with this rule will be problematic at best, absent having named a successor attorney who can readily step in and contact your clients, inform them of the situation, and advise them of their options. 3. The duty to safeguard client property. Rule 1.15 requires you to properly safeguard client funds and property. Without a plan, no one may have the authority or information needed to access your trust account, return client files, or distribute funds properly. 4. The duty of confidentiality. Under Rule 1.6, you are required to take reasonable steps to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. Here again, if you're no longer available, compliance with this rule could be a tough one for someone else to pull off if you failed to leave any specific instructions regarding secure communication and file transfer protocols and/or the secure use of network resources. And finally, 5. The duty of competence. According to Rule 1.1, competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. As I see it, the reasonably necessary preparation you are to take includes planning for the foreseeable, and a disability, incapacitation, or untimely death are all foreseeable events. Planning for them is part of being a competent lawyer. It's as simple as that. So I encourage you to keep these rules in mind. They will provide useful guidance as you develop your own succession plan, just as dismissing them outright will eventually bring about unintended consequences. Consequences that could all too quickly cause harm to one or more clients and damage the reputation you spent years building. If you don't yet have a plan in place, now's the time to make it a priority, because in the end, one just never knows.